What if I told you that the family immigration process you've depended on for years is about to change in a dramatic way? Thousands of families across America are waking up to the reality that bringing their loved ones to the United States has just become far more complicated. In January 2026, the Trump administration announced major changes to I-130 family petition rules that could impact your ability to sponsor parents, siblings, spouses, and children. If you have a pending petition or plan to file one, the next few minutes could decide whether your family stays united or remains separated for years ahead. Hello everyone, you're watching Next Step USA, and I'm your host, bringing you the most critical updates on American immigration, visas, and policy changes that directly affect your future in the United States. Today, we're breaking down the Trump administration's latest announcement regarding family-based immigration and the I-130 petition process. These changes are scheduled to take effect in early 2026, and if you don't understand what's happening, you could face serious delays, denials, or even permanent separation from your family members. Make sure you watch this video until the very end. Take notes, and please subscribe to Next Step USA so you never miss an important immigration update that could change your life. Let me start by explaining what the I-130 petition is and why it's so essential to family immigration in America. The I-130, officially known as the Petition for Alien Relative, is the foundation of family-based immigration to the United States. This is the form that U.S. citizens and lawful permanent residents file with USCIS to establish a qualifying relationship with a foreign family member. Once the I-130 is approved, it confirms that you have a valid family relationship, and your relative can then apply for an immigrant visa or adjust their status to become a permanent resident. The I-130 covers different family relationships, including immediate relatives like spouses, unmarried children under 21, and parents of U.S. citizens, as well as preference categories for siblings, married children, and adult children. For decades, family reunification has been a cornerstone of American immigration policy. Millions of immigrants have used the I-130 process to bring their loved ones to America legally. But in January 2026, the Trump administration announced significant policy changes that are reshaping how these petitions are processed, reviewed, and approved. These are not small technical tweaks. These are fundamental policy shifts that reflect the administration's broader approach to immigration enforcement and its goal of reducing overall immigration numbers, particularly in family-based categories. The first major change involves significantly increased scrutiny and documentation requirements for I-130 petitions. Under the new guidelines, USCIS is requiring petitioners to submit substantially more evidence to prove the legitimacy of family relationships. In the past, basic documents like birth certificates, marriage certificates, and proof of the petitioner's citizenship or permanent residency were usually enough for straightforward cases. Now, the Trump administration is implementing what they call enhanced vetting procedures. This means even routine I-130 petitions will face far more intensive review. USCIS is now requiring extensive documentation of the relationship's history, financial interdependence for spousal petitions, detailed affidavits from third parties, photographic evidence covering the entire relationship, and in many cases, certified translations of foreign documents from approved translators. What this means in practical terms is that preparing an I-130 petition has become significantly more complex and expensive. You may need to hire immigration attorneys or consultants to help compile the required evidence. You'll need to obtain official translations of documents. You'll need to collect affidavits from friends, family members, and colleagues who can confirm your relationship. And even with all this additional documentation, processing times are increasing because USCIS officers are spending more time reviewing each petition. Cases that once took 6 to 12 months are now taking 18 months or longer, and that's just for the I-130 approval, not the full immigration process. The second major change involves stricter financial requirements for sponsors. When you file an I-130 petition, you're not only proving a family relationship, you're also committing to financially support your relative so they don't become a public charge in America. This is done through Form I-864, the Affidavit of Support. Under previous administrations, the income requirement was set at 125% of the federal poverty guidelines for your household size. If you didn't meet that threshold, you could use a joint sponsor, usually another family member or friend who met the income requirement. The Trump administration is now making major changes to these financial standards. First, the income threshold is being raised. While the exact percentage hasn't been finalized, proposals suggest it could rise to 150% or even higher of the poverty guidelines. Second, the administration is restricting the use of joint sponsors, making it harder to qualify if you personally don't meet the income requirement. Third, assets are being scrutinized more carefully, and simply having assets may no longer be enough to overcome income shortfalls. Let me give you a real-world example of how this impacts families. Under current rules, if you're a US citizen sponsoring only your spouse, you must show income of at least $28,000 per year, based on 125% of the poverty guideline for a household of two. That's already difficult for many Americans, especially those in low-wage jobs or facing unemployment. If the threshold increases to 150%, you'd need to show income closer to $33,000 or more. And if you're sponsoring multiple family members, such as your parents and spouse, the required income increases dramatically. For a household of four, you could be looking at income requirements of $50,000 or more annually. Many American families simply don't earn that much, particularly in lower-cost regions or industries with modest wages. This effectively prices out working-class and lower-middle-class Americans from sponsoring loved ones. The third major change involves expanded grounds for denial and increased use of requests for evidence, or RFEs. RFEs are notices from USCIS asking for more information or documentation before a decision is made. In recent years, the rate of RFEs has increased sharply under the Trump administration's policies. Cases that were once straightforward approvals are now resulting in RFEs that require petitioners to submit extra evidence, explain inconsistencies, or clarify aspects USCIS finds questionable. The new 2026 guidelines expand the reasons USCIS can issue RFEs or deny I-130 petitions outright. Officers now have broader discretion to question the bona fides of relationships. They can deny petitions based on subjective judgments about whether a marriage appears genuine, whether family ties seem strong enough, or whether the petitioner has shown sufficient commitment to supporting their relative. Additionally, USCIS has been instructed to take a much stricter approach to inconsistencies, no matter how minor. A small error in a date, a spelling difference in a name, or failing to list an old address from years ago. Issues that were previously overlooked or easily corrected are now being used as grounds for RFEs or denials. The message is clear. The administration wants to make family immigration as difficult as possible, hoping that increased complexity, cost, and uncertainty will discourage people from sponsoring family members at all. Another critical change involves the priority date system and visa bulletin retrogression for family preference categories. Annual numerical limits on visas create backlogs, especially for countries like Mexico, the Philippines, India, and China. Your priority date is the day your I-130 is filed, and it determines your place in line. You can only move forward when your priority date becomes current, according to the monthly visa bulletin. Under the Trump administration, priority dates are advancing more slowly. The State Department is under pressure to slow family immigration. This means even if your I-130 is approved, you may wait many additional years before your family member can come to America. For siblings of US citizens from the Philippines, wait times already exceed 20 years. Under the new policies, these waits could extend to 25 or even 30 years. The fifth major change involves increased scrutiny of adjustment of status applications for immediate relatives already in the United States. Many people file I-130 petitions for spouses or children who are already in the country on tourist visas, student visas, or even without legal status. Historically, immediate relatives of US citizens could adjust status even with periods of unlawful presence. The Trump administration is now tightening enforcement. USCIS is taking a harsher view of overstays and unlawful presence. Even immediate relatives are facing more scrutiny, longer delays, and higher denial rates. Officers are looking for any reason to deny cases, including minor violations, missing documents, or suspected fraud. If your spouse entered on a tourist visa and you married soon after, USCIS may suspect visa fraud and investigate extensively. Let me also address the impact on specific family categories. For US citizens sponsoring spouses, the new rules require extensive proof that the marriage is genuine. USCIS is conducting more interviews and asking detailed questions about your relationship, finances, daily life, and future plans. For parents, the same enhanced documentation and financial scrutiny applies, and any past immigration violations will be reviewed more strictly. For lawful permanent residents sponsoring spouses or unmarried children, the challenges are even greater due to longer wait times and increased scrutiny of the sponsor's own status. For siblings of US citizens, the situation is especially difficult. The F4 category already has the longest waits, and there is discussion about eliminating it altogether, showing the administration's intent to sharply reduce family-based immigration. Now let's talk about what you can do. First, file your I-130 as soon as possible to secure your priority date. Second, prepare the most thorough petition possible with extensive evidence. Third, seriously consider hiring an experienced immigration attorney. Fourth, ensure you meet financial requirements and understand joint sponsor and asset rules. Fifth, be completely honest and accurate on all forms. Sixth, respond quickly and thoroughly to any RFEs. Understand your appeal options if denied and stay informed through reliable sources like Next Step USA. For pending petitions, USCIS may apply new standards even if you filed earlier. Respond carefully to any RFEs. Also consider alternative immigration options if applicable. Avoid common mistakes such as rushing applications, hiding past violations, failing to maintain status, or not updating USCIS about changes. These errors are more costly under stricter rules. The Trump administration's approach represents a major shift away from family reunification. These policies are designed to reduce legal immigration, meaning more tightening ahead. These changes make family immigration harder, longer, and more expensive. But with preparation, legal guidance, and persistence, families can still succeed. Here at Next Step USA, we're committed to helping you understand these changes and make informed decisions. If this video helped you, like it, share it, and subscribe to Next Step USA with notifications on. Drop a comment with your questions or topics you'd like covered. Remember, knowledge is power. Prepare early, stay informed, and don't give up. This is Next Step USA, and I'll see you in the next video. Stay informed, stay prepared, and keep fighting to reunite your family. Take care.